This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight we're taking calls and questions about dangerous and defective products. When a product hurts you, it's natural to want to blame somebody. Maybe it's the manufacturer of the product. Is that who you blame? Or is it the store where you bought the product that you complain to? Okay, is it possible that you used it wrong and maybe it's your fault? Product liability cases are really difficult. They're hard to prove sometimes. You need an expert to help you figure out what you've got and how to walk through the steps. So tonight we're taking calls and questions about dangerous and defective products. You can also email a question. Send your email questions to lawcall@waaytv.com. You can send a legal question on any legal topic any day of the week. And when we get to a show that's on point, we will pull some out. And we've got some tonight about dangerous and defective products. Michael Timberlake and Heath Brooks are with us tonight from Timberlake & League answering questions about this. You guys do these kind of cases, right?
Yeah, absolutely.
A lot of people are confused about what sort of product liability cases are, like some examples. And yet, I bet you see them and you hear them in the news all the time.
Right. I mean, you know, the most common product liability case you see is are either, you know, drug manufacturing cases or automobile manufacturing cases. And typically the reason for that is because when there is a design defect or a manufacturing defect in one of those types of things, the harm can be widespread. It can happen with a lot of vehicles, a lot of drugs, so there can be the same or similar type harm happen to a lot of people. So you do have that type of situation.
Gotcha. And we've got a graphic of some of the types of things. Heath, walk us through some of these.
You know, we've seen this from time to time. Your stove catches on fire for no reason. And you know, is it a problem with the manufacturing of that stove? Is the stove designed improperly? We see it from time to time, particularly around the holidays, a toy with a choking hazard. You know, is this something that you know should have occurred? Is this a problem with the actual toy's design? Was it just this one particular toy manufactured inappropriately? Airbags have been in the news a lot lately, the Takata airbags, which exploded, sending shrapnel everywhere. Obviously, that is not supposed to be the way an airbag explodes. It's supposed to protect you and not harm you in that kind of manner. So that is a particular definition of a product case. One type of case that we deal with very regularly, and we see a lot of the advertisements of things about, are medication products cases, which is where a manufacturer, most of the time the manufacturer of the medication has either been aware of a side effect and not disclosed it to individuals, or not done enough research to determine whether that medication should have been on the market. And so, you know, we have handled those types of cases dealing with medications. Another type of products case that we hear a lot about is in the food service industry. A lot of people don't think, hey, look, I go into a restaurant and I eat something that is spoiled or is rotten. How is that a product? But under Alabama law, when you eat food in a restaurant that's not fit for consumption, that is a potential products liability claim. So we handle that under the Alabama law. The Alabama Extended Manufacturer's Liability Doctrine is a fancy legal term for it. Under that law, we can actually bring an action against a restaurant for providing you food that you shouldn't be eating.
Gotcha. Okay, but lawyers have to prove specific things, right? What do you have to prove when you've got a products liability case?
Yeah, I mean, absolutely. The biggest thing that people need to know about Alabama's products liability law is it's not strict liability. There are other states that have what we call strict liability, which just simply means if someone produced a product, put it in the stream of commerce, and the ultimate end user was injured by that product, then the manufacturer can be liable. In Alabama, it's not that way. You have to prove fault. You have to prove that the product was unreasonably dangerous in some way. It could be a design defect, it could be a manufacturing defect, but you have to be able to prove some element of fault on behalf of the producer of the product to show that they knew or should have known that this injury was going to happen or could happen, or that they knew about a particular problem with the product and failed to warn about the potential hazards presented by that product, to warn the end user of the hazards with the use of a product.
Okay, we've got callers with questions. We've got Stacy on the line with a question. Stacy, thanks for calling. What's your question tonight? Hey, Stacy, what's your question tonight?
Hi, my 7-year-old daughter was injured on a swing set we bought a couple months ago.
Okay.
Because the chain on the swing broke. And so we called the swing set company, and they referred us to an insurance adjuster. So the adjuster calls me and says he wants to settle, and I need to send him copies and pictures of anything relevant. How do I know what to ask him for? What is a reasonable amount to ask for? My daughter had a severe break to her radius and scraped through her nose and her forehead, and she spent 2 months in a cast and lots of other discomfort. So any advice you can give me about how much I need to ask for would.
Yeah, and does she need a lawyer to help her figure out what to ask for?
Well, I mean, in many cases involving a serious injury, you're definitely going to need a lawyer to be able to accumulate the data and the information to provide to the insurance company. A lot of times insurance companies will make offers out of the box or quick offers in some claims, especially in auto claims. But you need to be careful about what you're considering when you do that, because you don't know the rules. You don't know necessarily the law. The people that you're dealing with do. But in general, damages that you can get in these types of cases are clear, and they're in pretty much every personal injury claim, right, Heath?
Yeah, I mean, in your particular situation, your daughter would be entitled to the medical bills that she incurred or that you actually incurred as her mother, because the child's not paying these medical bills, and you would have your own claim to get these medical bills paid back. Your daughter would also be entitled to any kind of pain and suffering that she went through. When we think of things like missing school, missing time on her team, or missing time playing with her friends. Those are all types of damages that your daughter would be entitled to, and not to mention the long-term problems that she may have. Does she have any long-term issues with the fractures that she had? Or is that going to cause her problems as she goes about her life? And those are things that we would need an opinion of her doctors to determine whether or not she would be entitled to all of those damages. So before you actually make a demand to an insurance company or ask an insurance company for money, it is very important that you consult with an attorney so that we can line those types of damages up to figure out exactly what your daughter would be entitled to. And the other thing is that I wouldn't necessarily send any of the product, the chain, or anything like that to the actual swing set manufacturer, especially if there may be multiple parties that are responsible. For instance, the manufacturer of the chain and the individual who had manufactured and put all those parts together to create the swing set. So there are a lot of issues that would need to be investigated, not just regarding what your daughter would be entitled to, but also who's at fault for what was caused to her.
What if mom had to take off from work to stay home with an injured child? Can you claim that?
Yeah, absolutely. In Alabama, one of the elements of damage is a parent's loss of time or the cost of caring for an injured child. So that's something you have to keep up with, but it is something that we would look into.
Okay, we've got Gwen on the line with a question. Gwen, thanks for calling. What's your question tonight?
Hi.
Hi.
I use the hair removal product, and I've used it many times over the years, but this particular time I used it, the back of my leg swelled up. I ended up having to go to the emergency room. Is there any legal recourse?
Okay. A hair removal product. Is that a product liability kind of case?
It could be. It could be.
Yeah, it can be. It's harder to prove products liability in a one-off incident. If you've got a situation where this one person had this reaction to this product under specific circumstances, and not a whole lot of other people had it,
okay,
then it can be difficult to prove. But if there's other people that have it, that evidence helps you.
It does, and one of the things with a one-off situation like that is, and it's the number one rule of products case, you gotta have the product, because there are two types of potential product liability claims that we look at. One is called a design defect, and what that means is that the manufacturer of all the cars, when they manufactured it, there was a design defect in the manufacture of those vehicles so that they are all dangerous. And then the other type is a one-off manufacturer's defect, which means that one particular bottle of hair removal had something wrong with it. And the manufacturer of those products can be responsible in both sorts of scenarios. But the only way we can prove it, the only way we could prove that maybe there was bleach in that bottle when there shouldn't have been, is if we have the product. And if you don't have the product, generally it's very, very tough to make a claim.
So save it, but
Yeah.
also
Save it.
don't send it. The company may ask you for it, right?
Absolutely.
And you don't do that.
Well, you want to make sure that you've done your investigation, any testing that you want to do on the product before
Okay.
you ever turn it back over.
Okay.
That's right.
Okay. They're telling us to take a break. We'll take a break. Be right back answering more of your questions about product liability cases. Stay with us.
You're watching WAAY 31 Law Call, where lawyers come to help. Your rights, your calls, live. Hosted by family law attorney Sharon Doviet. With the personal injury attorneys of one of the Valley's most respected law firms, Timberlake and League. Featuring the knowledge of managing partner Michael Timberlake, with millions of dollars awarded to his clients. And the experience of attorney Will League, a strong courtroom fighter known for his commitment to winning. And the fellow partners of Timberlake and League Heath Brooks and William Meservey. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. Tonight we're taking calls and questions about product liability cases. So when a product hurts you, we've got with us Michael Timberlake and Heath Brooks, both from Timberlake and League, and we've got callers with questions. We've got Blake on the line with a question. Hi, Blake. Thanks for calling. What's your question tonight?
In regard to drug manufacturers' recall or product defects, such as medicine, who sets the determination if that is going to be a class action lawsuit, and what limitations are there placed and who's in charge of that on the actual damages that can be awarded in regard to drug recall cases?
Yeah, who decides it's going to be a class action?
Well, I mean, what you've seen here is that the term class action is kind of a legal term that a lot of people think just means when there's a lot of people that are injured. That's kind of morphed into the term that we use now, which is a mass tort action. In a class action, you can have one plaintiff and they sue on behalf of a lot of other people, so individuals don't have their individual claim. The money's collected and it's divvied up amongst the persons. But there are a lot of pretty strict requirements to establish a class action, and a lot of it has to do with the injury or damage that's associated with it. So what we've seen here in the last decade is that they're more of a mass tort situation, which means everybody has an individual lawsuit, and they're based on similar facts, typically a product. Drug products are the ones we see the most often, and then those individual cases are all combined together in a multi-district litigation, typically in federal court, and they're all kind of put together for purpose of prosecuting the cases. The court will assign counsel as a steering committee or a number of law firms that are in charge of doing the basic discovery that every firm would do in the case. But it's a much more efficient way to basically get your case ready to go to trial, and then you can make a determination about where you go from there. And the way they come up with settlement values is really kind of interesting as well, Heath.
Yeah, I mean, a lot of times with these cases, but sometimes what will happen in a multi-district litigation situation is there'll be a couple of cases that are tried as a test basis to see what juries how the juries are gonna review the evidence, how the juries are gonna determine damages, and then that can be used as a kind of the yardstick for determining the value of these cases for other plaintiffs that are involved. You can go further than that, and oftentimes in these cases, which is what keeps them out of a class, are the gravity of the injuries to the individual plaintiff. So if you have the worst case scenario happen where a particular person has actually died because of defective medication, that may be a worse damage than someone who suffered another, maybe they had cancer, but maybe they've overcome cancer and continue to live with their life in relatively good health. So you will take all these particular cases, looking at the medical bills that have been expended, looking at the amount of medical treatment, looking at what actually happened at the end, and there will be literally a chart that is come up with and agreed upon by all the lawyers that are present to determine what each claim would be worth to these individual plaintiffs. There's a lot of differences with a multi-district litigation type of situation than a class action, in that individual plaintiffs oftentimes have a lot more freedom to determine what the value of their case would be, whether they're going to accept the offers or not. you know, as pertaining to a class action where you may get a notice in the mail that says you can opt in or opt out, and if you don't hear from me, well, I'm sorry you stuck with the, you know, few dollars you get while the attorneys make all the money, which is what a lot of people think. So, you know, it can be very beneficial to plaintiffs, and we find ourselves in those, oftentimes in those types of cases, as opposed to class actions.
Yeah, you see some of those flyers you get in the mail and you get $12 maybe,
Right,
or a
right.
buck or something. So that's not even what.
Well, and
that's
a
not
lot of times those cases are, you know, the lawyers are doing a good job. They're done a job for consumers, and they've done a job for a lot of consumers. But the individual result is maybe nominal.
Okay.
But at least they're stopping the behavior of the corporations from doing that.
Yes, and future companies from doing it too.
Sure.
Okay, so when we've got something like that, do I need a local lawyer? If you're talking about these cases are going to be tried somewhere else in another district, do I need a local counsel here in Alabama? Do I want my own lawyer? Can I even get my own lawyer?
Yeah, it's not gonna hurt you to go through somebody that you know and trust, and that you can go into their office and that you can talk to that person. You can ask questions on the phone, as opposed to somebody that's
You never meet.
It's on a 1-800
Right.
number, you know.
One of the very important thing about that, oftentimes when you have a multi-district litigation where you have lawyers all across the country that sometimes have a large number of clients, and the court may appoint a lawyer or a law firm to handle those cases, having a local lawyer is important when you have your medical treatment in the area where you live. Because oftentimes depositions need to be taken, medical records need to be gathered. You know, communication needs to be had between a local lawyer, a client, and then maybe a national law firm that is been appointed by the judge. So it's really important to have a local lawyer, particularly if your medical treatment was obtained where you live.
Gotcha.
And you know, a lot of local lawyers, and our firm included, we work with other firms that are, you know, that are handling these claims. You know, that doesn't cost any more to have a local lawyer that's working on your case, and we can, you know, guide people to the right firms as opposed to just, you know, calling somebody that advertises on TV.
Gotcha. Okay, we've got Jana on the line with a question. Hi, Jana. Thanks for calling. What's your question tonight?
I was the driver in a single car accident, and I was injured when the airbags in the driver's side did not go off, and I had my seatbelt on, but there was no passenger in the car, and all the passenger side airbags went off. And I had a bad head injury with black eyes and everything.
Okay.
And I was just wondering about product liability with airbags.
Yeah, if your airbag doesn't go off,
Right.
is that a product liability case?
You know,
Could be.
yeah, it can be. You know, it's one of those situations. In order to prove a product liability claim, you have to be able to prove that the product was dangerous or defective in some way. So in Alabama, in an airbag situation, that would require you to prove through an engineer that there was a defect, and you'd have to have somebody, you'd have to pay them to come in to inspect and to do the research that was necessary to establish that the product was defective. You also have to prove that the defect caused that harm. But sometimes it can get, you know, a little bit economically challenging.
That's right. You know, one of the things about airbags just in general is that there has to be a particular set of circumstances for an airbag to deploy that creates a better situation for the passengers and the driver of the car. So for instance, if your airbag deploys when you are not decelerating at 25 miles per hour in the front, or that you're not hitting at a 90-degree angle to whatever is stopping you, when the airbag deploys, that could cause more harm than good. That in and of itself could be a product liability situation. And every time you deal with a situation particularly involving an airbag or a rollover case where the top of the ceiling crushes down and causes more injury than what could happen, you have to evaluate whether or not the gravity of the injuries are going to, and whatever jury verdict you may get, is going to be outstripped by what you have to spend in order to get to that jury verdict. Kind of like a Pyrrhic victory. So you may win, but you end up losing because you put more resources into that particular case than what a jury would ever give you. That's why when you're dealing with a type of car wreck that's not a catastrophic sort of situation or a very, very significant injury, and not making light of anybody's injuries, what you don't want to get into a situation is where after 2 to 3 to 4 years of litigation with a major automobile manufacturer, the jury gives a positive plaintiff's verdict, but your client looks over at you and says, hey, look, we got a verdict, but I wish you had told me that it wasn't going to be that much because I wouldn't have done all this to get there.
Yeah.
Yeah, I mean, you know, I worked on a case one time where it was multiple injuries and deaths, and it was a pickup truck. And the firm that we were working with at the time, we had to make a decision, and what we ended up doing, we had to buy 2 new pickup trucks that were very expensive so that we could use those as exemplars to prove the fuel leak that we had in our case that caused the problem.
Yeah.
So, I mean, it's enormous. Now, it came out well for folks, and we had very skilled people working with it, but it can be very, very expensive to do what you have to do to prove the case.
Okay, so cases like that, are you expecting the client to come up with the money to pay for those trucks, or how does that work?
No, you know, we handle these claims on a contingency fee basis, and we will set the contingency fee based upon the risks that we have and the you know, the complication, the complexity of the case. So in those types of situations, we advance all the costs, and then if there's a recovery, you know, we get our costs back and we get our fee. And if not, then we take it on the chin.
Okay. The client does not foot that. Okay. No. We got this email question. I'm going to skip down to Russell. Russell had said, I opened a can of peas and I found a headless roach of some type. The bug was discovered before it was eaten. In fact, I had saved it to return to the company with a letter of complaint. Is there a legal action to take in that case?
This is Heath's specialty.
I had your case, Russell. I had your case. There was a caterpillar in a popular brand's bag of potato chips. Turns out they ate it. You know, the caterpillar wasn't supposed to be there. Turns out that this particular caterpillar, after I hired an entomologist to evaluate it, was a delicatessen in Peru. So it was completely edible, could not cause any harm. A caterpillar in a bag of chips couldn't cause any problems for this person. So without damages, we didn't have a case. In that kind of situation, if you do find a roach in your can of peas or whatever, is it supposed to be there? No. Is it fit for human consumption? Probably not. If you don't eat any of it and it doesn't make you sick, you don't have the ingredients to bake a cake, and you're not going to have a case.
Okay. And you might be exposed to a delicacy in Peru.
That's right. You know, it's crazy. Okay. People eat roaches.
There's somebody everywhere, right?
Let's
take a break. Answer more of your questions about product liability cases coming up. If you didn't get your questions answered tonight, here's how to get in touch with Michael Timberlake and Heath Brooks. They are with Timberlake & League. They are personal injury attorneys, so that's everything from product liability cases to auto accidents. The number in Huntsville, 256-536-0770 or 800-804-2502. The website, law-injury.com, and you can like them on Facebook and learn more about the law that way.
And our friend Sharon does family law, which is child custody, divorce, child support. She does a great job with all these cases. 256-539-7337. Or you can find her on the web at SharonFamilyLaw.com.
Thanks for all your calls and questions, and we'll see you next week.
Thank you. Have a good night.